the provincial governor of Cagayan, the Supreme Court issued a TRO.
Gov.Mamba is now the subject of a show cause order because what happened perhaps after the hearing of one of the honorable committees of this chamber, Your Honor, there was a withdrawal apparently of the petition that he filed, so he was asked to show cause, Your Honor.
Masyado niya po, masyadong magagaling. Bakit kailangan hanapin po niyo? Kami po meron kaming South Lounge dito. Wala na pong rules doon. Kung saan kami uupo, kung anong kakainin namin, kung ano yung magsisilbi sa amin. This is
Sa kapagpalang araw po sa atin lahat mga kababayan, kini-question ni Congressman Marcoleta ang Supreme Court sa pamamagitan ng court admin ang kanilang pakikialam or ika nga yung pag-issue ng TRO, Temporary Restraining Order, sa kanilang cite and contempt na ibinigay dito kay Gobernador Mamba dahil sa kanyang hindi pagdalo kahit pa ilang sumon ang pinadala sa kanya kasama ang kanyang mga tauhan na hindi niya pinayagan na pumunta sa House of Representatives. Kaya napilitan itong silang mag-cite and contempt. Ngunit ang hindi nagustuhan ng committee at ni Congressman Marcoleta, bakit nag-issue umano ng temporary restraining order itong Supreme Court sapagkat wala sila umanong karapatan na baliin ang desisyon ng House of Representatives. Lalong-lalo na ang kanilang desisyon na pag-contempt ay may tamang pagbabasihan. Kaya medyo uminit talaga itong si Congressman Marcoleta dahil tila ba parang pinapakialaman umano ng Supreme Court ang kanilang kapangyarihan.
last August 24, while a joint committee was having a meeting in regard to the implementation of the order of contempt and on the order of detention over the person of the provincial governor of Cagayan, the Supreme Court issued a TRO. We were surprised why in the legitimate and constitutional function that Congress is doing, a TRO was issued by the Supreme Court. May we know the reason, Mr. Chair?
Please, Honorable.
Yes, Your Honor. Thank you, Your Honor. Well, there is a petition that was filed, Your Honor, before the Supreme Court, and that was the subject of assessment and deliberation, Your Honor, and perhaps that's the reason why, based on that petition, the Supreme Court issued that particular TRO, Your Honor.
So, Mr. Chair, are we made to understand now that the Supreme Court is abandoning a landmark case dated July 18, 1950? We can go back to the Arnold versus Nazareno case and the other cases. In this case, sana huwag mo kimamay, no? So I'm explaining, no? Sabi rito sa Arnold versus Nazareno, 1950 case. Alam naman po nating lahat yun. The very reason for the exercise of the power to punish for contempt is to enable the legislative body to perform its constitutional function without impediment or obstruction. There is a twin case there, Mr. Chair. Arnold versus Balagtas, 17 Philippine Reports 358. Na-detain po rito yung petitioner. The Supreme Court refused to order his release and deferred to the discretionary authority of the legislative body to punish contumacious witnesses for contempt. The exercise of the legislature's authority to deal with defiant and contumacious witnesses should be supreme and is not subject to judicial interference, except when there is manifest and absolute disregard of discretion and a mere exertion of arbitrary power. Mr. Chair, tinatawag po pamagitan ng order of contempt and detention si Gov.Mamba for his refusal to answer a show cause order from the Joint Committee, and for refusal to issue travel authority for the people called by the committee to testify, to shed light on the issues being deliberated, and for maligning the members of the committee in his radio program. So, while we were in our duty to receive him and make his explanation, hindi po pala namin alam, on August 22, he filed a petition before the Supreme Court with a prayer for TRO. To us, that was an insult. So, as a matter of fact, Mr. Chair, we could disregard the TRO because the Joint Committee had jurisdiction over the person of the provincial governor at 9 o'clock in the morning. The TRO came at 5:53 in the afternoon. Pero ayaw namin gawin yon in respect to a co-equal branch of government. So ang ginawa na lang namin, pinauwi namin, but for him to assign an undertaking, na i-withdraw na lang yung petition niya, and upon receipt of the received copy from the Supreme Court, there should be an automatic lifting of that order of detention. Hindi ko po alam kung ginawa niya. Pero yung medyo masakit po rito, there are a lot of jurisprudence. For example, Sabio versus Gordon, 2006 case. The right to pass laws necessarily implies the right to obtain information upon matter which may become the subject of a law. It is essential to the full and intelligent exercise of legislative function. Neri versus Senate of the Philippines. Ito po yung dissenting and concurring opinion ni Justice Carpio. The two principal means of enforcing the power of inquiry are for the legislature to order the arrest of a witness who refuses to appear and to detain a witness who refuses to answer. The power being inherent in the legislature, essential for self-preservation and not expressly withdrawn by the Constitution, forms part of the legislative power vested in Congress. Alam po ba ninyo yung, Mr. Chair, yung mga allegations na nakalagay po sa petition ni Gov.Mamba that I think hurt the members of the Joint Committee most. So sa paragraph 18 po ang sinasabi niya ron, the unfortunate reality is that the congressional power of inquiry remains to be used as a tool for mere political retribution. That's not the reality in Congress, Mr. Chair. Sa paragraph 20, sabi po niya, how many more citizens must bear the abuses made in the guise of congressional inquiries? How many more contempt orders will be tolerated to punish and humiliate persons invited to appear before congressional inquiries? This is the kind of petition that was received by the Supreme Court and for which we were TRO'd, Mr. Chair. Can we get a better explanation than that?
Your Honor, may I just state, Your Honor, that the issuance of the TRO does not mean that previous rulings or doctrines of the Supreme Court on the matter, Your Honor, have been abandoned. This is a preliminary or provisional remedy that is something that the Supreme Court can look into, Your Honor. Likewise, it's not a final disposition of the case. May I just also state for the record, Your Honor, that as of the present, the Gov.Mamba is now the subject of a show cause order because what happened perhaps after the hearing of one of the honorable committees of this chamber, Your Honor, there was a withdrawal apparently of the petition that he filed, so he was asked to show cause, Your Honor.
Mr. Chair, nabasa naman po ninyo sa petition nila na sabi niya, the power to arrest is not even in the rules made of legislation. Yung mga abogado niya po masyadong magagaling. Bakit kailangan hanapin po niyo? Kami po meron kaming South Lounge dito. Wala na pong rules doon. Kung saan kami uupo, kung anong kakainin namin, kung sino magsisilbi sa amin. This is very basic. Question is, alam po ninyo yung power to punish for contempt? Why would you issue a TRO? This is basic. Alam namin na hindi na dispose yung merits ng case. But the fact that you issued a TRO to a co-equal and coordinate branch of government, what if Congress will file a bill removing the judicial power of review? O yung paggawa ng rules, hindi na po sa inyo, kami na lang ang gagawa. We cannot do that. Ito po yung sinasabi namin na sana paano natin makukorek ito. The TRO was there already. And we were made to comment in 5 days. Sir.
Your Honor, like I mentioned, Your Honor, first is that is not a disposition of the case. Second, Your Honor, the evaluation being done includes the totality of the petition, Your Honor. There is nothing that is being focused on for purposes of that evaluation, Your Honor. So I would want to believe that that was not only, as mentioned by Your Honors, the only basis for coming up with the TRO, Your Honor. And again, may I just state that at present, the said petition is now the subject of a show cause insofar as the petitioner, Gov.Mamba, is concerned.
That's it. That's a separate matter already. That happens because I asked him to make an undertaking because we wanted to prevent a constitutional crisis here. Hindi ka rin namin pwedeng pauwiin ang hindi mo pinipirma nito. Sa tingin po namin, yun lang ang paraan para ma-alarm din kayo na hindi nyo alam itong nangyayari. Umaga pa lang, nasa amin na ito eh. And then when we asked for a TRO, the Supreme Court was kept in the dark also. Pero ang inihingi lang namin dito, habang ginagawa po namin ang aming constitutional duty, wala naman po sanang TRO. You could have received this petition without issuing a TRO. That's the whole point, sir.
Your Honor, with all due respect, we, insofar as the matter is concerned, everything, all actions of the Supreme Court, of course, starts with what alleged in the petitions, Your Honor. Any subsequent event, Your Honor, if it's not brought before it, is something that I cannot take into account, Your Honor. That's also part of jurisprudence. But let me just state for the record, Your Honor, there is nothing being abandoned. Second, Your Honor, in fact, the Supreme Court has always upheld the power of inquiry in aid of legislation of Congress insofar as Section 21 is concerned. Even the latest decision of the Supreme Court in the Ballad case, Your Honor, emphasizes that, Your Honor.
That makes the TRO unnecessary, right?
Your Honor, as a former judge, I will be the last, not the first, not to assail, of course, the decision of the Supreme Court, especially if it's a preliminary action on its part, Your Honor.
Your answer is yes.
No, Your Honor, my answer is no. That's not, that it's not, to me, as a, personally, Your Honor, I hope you don't mind. As a lawyer and as a former judge, Your Honor, I'm not answering as a current court administrator right now, Your Honor, but I would want to believe that it is something that I have to respect, Your Honor. Thank you.
Hindi na TRO ngayon eh. Is the TRO necessary? You can receive the petition without issuing the TRO, considering yung ginawa niya.
That is correct, Your Honor, but since there is a prayer, Your Honor, and the court in its initial assessment decided to issue it, that is, if it was not there, Your Honor, then that would have been wrong.
So the initial assessment of the court is that the unfortunate reality is that the congressional power of inquiry remains to be used as a tool for mere political retribution.
No, Your Honor, like I said,
Ito yung allegation niya eh.
yes,
And for which we receive a TRO.
with all due respect, Your Honor, what I would just like to say is that, as I earlier mentioned, the totality of the petition is what is being looked into, and there is no particular focus on an allegation or statement alone, Your Honor.
What is the totality? What is the total picture that has been pictured by the Supreme Court in issuing the TRO? He
Okay.
refuses to answer a show cause order. He refuses to issue travel authority to the people called by the committee. He continues to malign us in his radio program. What is the totality of the picture there?
May I just state, Your Honor, that that is only as far as I can go regarding this particular petition. I'm not a member of the court, Your Honor, but I don't want to second guess why they decided to issue the TRO, Your Honor.
Thank you very much, Mr. Chair. Gusto ko lang record na manifestation because I think that is something that we should. It should be a continuing review on this, Mr. Chair. Thank you. Thank you very much.
Thank you.
Salamat din po.
Mr. Chair, point of order.
Yes, what's your point of order?
Yes, according to our rules define, it's very clear that the right of every congressman to cite during a hearing anybody in contempt is our duty. And it's part of our rules. So I suggest that we revisit our rules rewriting and clarify this issue because it's a constitutional issue.
Yes, your point is noted, Congressman Romero.
Yes,
I would like to advise all the members to let us focus on the budget presentation as well as on budget hearing. You can have all your chances in the next committee hearings to that effect.
yes, Mr. Chairman, but my question really is the right to contempt a prerogative of the House rules?
Yes,
And-
we all agree on that.
And it's innately our own prerogative to cite anybody in contempt as a co-equal branch of government.
I subscribe to your point.
That's all,
Congressman
Mr. Honor.
Romero.
Thank you.
I would like to remind everybody that Marcoleta has an extended seconds or minutes because it is the prerogative of the chairman that the issue raised is a novel case. This is what we call constitutional crisis. So please bear with us. Next.